court is now in session. Honorable Keith F. White, Judge presiding. All persons having business before the court shall all near give attention and you will be heard. May God save the United States of America, the state of Florida, and this honorable court. Please be seated.
Thank you, Marshall Crawford. Good morning and welcome to this oral argument session of the 6th District Court of Appeal. I'm Judge Keith White and have the honor of serving as the presiding judge at our oral arguments here today. Serving with me today are Judge Joshua Mize on my right and Judge Rachel Kamoutsas on my left. Just a reminder that this is being both video and audio recorded, so please make sure that your phones and other electronics devices are on silent. We have several cases on the docket today. First case that we have is Gloria Walton v. Westgate Lakes. Both counsel ready to proceed? All right, counsel for the appellant. Normally, we set 5 minutes as sort of the default rebuttal time. Is that sufficient, counsel?
Yes, Judge.
All right. Are you ready?
I am.
All right, please proceed.
Good morning. May it please the court. My name is Chad Barr, and I have the privilege of representing the appellant in this case, Gloria Walton. We are here today because the trial court entered summary judgment in the appellee's favor on the issue of notice by application of the wrong summary judgment standard and when disputed issues of fact were present. The first issue is the summary judgment standard applied by the trial court. According to the trial court, in order for Ms. Walton to be entitled to rely on the inference that she slipped on rainwater tracked into the store, she needed to prove that inference to the exclusion of all other inferences. And I think it's important that we go to the trial court's wording. The trial court said, this is not an instance where the main inference underlying Ms. Walton's case could be established to the exclusion of all other inferences. So in essence, the trial court did not resolve all inferences.
Wasn't the trial court talking about when you're stacking inferences? So when you're typically in summary judgment, you can't stack inferences. Obviously, if you're just one level of inference, then the court has to take it all in the non-movement's favor, right? But you can't stack inferences in the non-movement's favor, right? So if ruling for the non-movement would require you to stack inferences, you can only do that if the first level of inference is in fact all other inferences are excluded, right?
Well, the issue of stacking of inferences, the court can stack inferences if you look at a set of facts and they lead to one conclusion, and that's what we're saying in this case is that.
So what you just said is if you look at a set of facts and they lead to only one conclusion,
right? That's
excluding all other inferences. That's what I mean. When you stack inferences, that first level of your stack, you do have to exclude all other inferences.
I don't think the case law supports that strong of a position. I think you can look at what we're saying in this case is that it's very simple, and I don't think there's any stacking of inferences in the first place. But what we're saying,
when you talk about the trial court standard, and we can talk about whether there was stacking of inferences, but with the way the trial court articulated the standard, that's what I took the trial judgment meaning as. She was viewing it as a stacking of inferences, and we can say she's wrong about that. But I don't think she inaccurately described the standard that applies when you stack inferences. Does that make sense?
I do understand what you're saying. But taking the court at its word, which is she did address the stacking of inferences, but she also said that we had to prove the inference, which is that the plaintiff slipped on rainwater to the exclusion of all other inferences. And in this case, that's the only inference that we're relying on. There's no other stacking of inferences. So in this case, we have the cumulative summary judgment evidence was that rainwater was regularly an issue inside the store. It was raining. 70 customers came in the store through that one path. That's the facts leading to the inference that there was rainwater on the floor.
So you had an assumption in there, and the assumption is that you described the condition as rainwater being in the store. And I'm not sure that's the right condition for purposes of 768-0755. Seems like the right condition would be rainwater in the spot, right? And it seems like that's where you and your opposing counsel disagree on the nature of the deposition testimony. It does seem to me like the idea that rainwater just can happen in a store, if that was the defined condition, then the store would always be on notice of rainwater anywhere in the store at any time. That would just kind of eliminate the whole requirement for constructive notice. Just the idea that water can get inside would mean they are always on constructive notice of water anywhere in the store. So since that would defeat the whole purpose of the statute, it seems like the relevant condition has to be there was water in this spot.
Well, I think that there's testimony that there was water in the spot. That was Miss Walton's testimony, is that there was a rather large puddle of water.
Wait, no, but hold on. You're twisting things, or not twisting, but you're responding, but I'm not.
I understand.
Espousing intent.
I
I mean, you're
understand.
getting to a different area. She testified she slipped on water. That doesn't go to whether this condition regularly occurred, right? Because you've got to establish one of two things for the constructive notice statute. You've either got to establish that this condition existed for a sufficient length of time, right? That it was the business should have known that the water was there, or that the condition occurred with regularity. Her testimony says, yes, I slipped on water. That has nothing to do with the constructive notice under A or B. So we were talking about B because you in your answer, described the condition that occurred regularly of water being in the store. And what I'm saying is, it seems to me like that defines the condition much more broadly than the statute would allow, because if you define the condition that we're examining the regularity of as water in the store, then literally no matter where water is in the store at any time, there would always be constructive notice. You see what I'm saying?
I'm going to try to answer your question the best that I can. The statute requires us to demonstrate, in order to prevail, to demonstrate constructive notice. Our position is that we demonstrated constructive notice, or at least demonstrated a genuine issue with respect to that, by virtue of the fact that, and this is coming straight from the case law, that rainwater was regularly tracked into the store when it rained. And this wasn't a normal rainstorm, this was a hurricane. So we have that, which goes to the issue of constructive notice.
Okay, so what you did, I articulated a problem with the standard you gave, and you re-articulated the standard. And so what I need you to do is address the problem that I identified. Okay, I need you to go a level deeper than you're going.
I don't understand, and
all right,
forgive me.
So there's two ways to define the condition that you're looking at the regularity of. One is water in this spot. Okay. The other is the broader way to look at it, water in the store generally. Okay, and that's what you're asking me to do. You're saying that there's testimony that water gets in the store, and that's the regular condition. That's how I view what you're saying.
The condition is the rainwater being tracked into the store. That's the condition. Exactly.
The store generally, as opposed to rainwater being in this particular spot that she fell or slipped, she didn't fall. But you see what I'm saying? There are two different conditions. One can be the rainwater being in this spot. One can be the rainwater being somewhere in the store. And you've said a couple of times that the condition was rainwater gets in the store, right?
Right.
Okay. If rainwater being regularly getting into the store generally gives you constructive notice of it being in a particular spot, right? Then that would mean that no matter where rainwater is in the store, at any place in the store, you always have constructive notice of it because rainwater can get in stores.
So we go to the testimony of Mr. Wampler, if I'm saying his name correctly. And he testified that rainwater is regularly tracked into the store in that area. He testified that.
Counsel, let me stop you there as a follow-up to what Judge Mize said. I believe, looking at the summary judgment evidence in the light most favorable to your client, that it was established that rainwater in what I'll call the foyer area did occur with regularity. By the foyer area, I mean the area between the two sets of glass doors where there was the warning marker and there was the mat. Are you with me?
Yes.
I understand Judge Mize's question that let's assume that we agree it was established with regularity that rainwater got tracked into that foyer area. His question is, does that mean as a matter of law that it occurs with regularity through the next set of double doors going not to the outside, but into what I'll call the store? Is that your position?
Well, yeah, I mean, our position is that area. And so there,
What area?
the area, when we're talking within 7 feet of the door, we're talking 7 feet of the front door, where you have customers walking in, and the video is very telling. I assume that you folks have seen it, but you have 70 customers walking in and out of there, shaking their umbrellas, shaking their ponchos. And it's not even necessarily
In the foyer.
also inside the store as well.
But where did the test? I think just tell you, we read the deposition testimony. And it does not, I see in the briefs the dispute on what the testimony established. And it seems to me that the better reading of the testimony is not that there was water in this spot in the store occurring with a regular occurrence. It seems to me the testimony established that water gets in the store and water gets in the foyer, however you say. And so I guess it goes, how do you define area, right? Like what, because this particular spot, it does not look like the testimony established that water occurred regularly there.
Mr. Wampler also said that there were times that the wet floor signs were placed in front of that set of doors.
That does not establish, the fact that they put water signs in a particular apartment at some unknown interval does not establish a regular interval at which water occurs in the spot.
Well, we're not trying to establish, we're just trying to say, is there a question of fact here? And so-
Okay, but you've got to have some testimony that could at least a jury could look at to establish that, right?
Yeah, I mean, yes, we do. And I think that with respect to the regular occurrence, I'm just struggling to see how a matter of
All right, so
2 or 3 feet can make a difference in where the customers are coming in and they're,
well, there's a set of doors there. There's actually a physical barrier, right? And one area is where people are much more likely to put a lot more additional water. Is that the first area they go into that has, a place to do the water, rugs. It's the first place they're shielded from the rain. So it's not just like it's an arbitrary 3 feet. It's actually a different defined area of the store. There's a structural barrier between the two areas, right? So can you address my question of if we look at this as the store generally, okay, just water gets in the store, which I think the testimony established. Doesn't that mean that if there was water anywhere in the store, they would be on constructive notice of it?
if there was a regular occurrence of water, I don't think that what we're saying is that they have constructive notice of water anywhere in the store. We're saying that there's constructive notice of water near the front door, which is,
And I think what you've heard us say is we don't think the testimony established that there was water in the inside, outside the foyer, in the inside of the store area. We think the best case scenario of this testimony for you is that it was inside the foyer, right?
well, let me
So I guess
go on.
in terms of you establish, are those one area or two different areas? And it seems like they'd be two different areas.
If that's how you guys see the evidence, and I understand that, then the other issue is the fact that it's within the site of the cashiers, which I think is a separate independent basis for constructive notice.
Did any cashier actually testify that they saw water on the floor?
That's not the standard for notice. That the standard is, are you in the proximity or vicinity of the area? And you could have seen it if you were doing what you were supposed to be doing. And that's what.
But didn't they testify that they were in the area and they could see that area?
They
and
did
you-
testify that they could see the area.
But there was no evidence that came out that they actually saw any water on the floor?
But that's not the standard. If we look at all the cases that we cited in our initial brief and our reply brief, the only thing the courts look at is were the employees in the vicinity of the incident that.
So which prong of the statute are you referring to?
So this is a element of establishing constructive notice.
So but
Proximity of
but
the-
you've got a statute that tells us, seems conclusively the ways we can establish constructive notice. And I agree, there was case law predating the statute that might have been different. We've got a statute now. Okay, and the statute, I think, was like 2011. It's not been around that long. I think I'll misspoke the date. 2010, 2010, I think it's right. So anything before 2010, that's not how we look at constructive notice for transitory foreign substances anymore. We've got constructive knowledge may be proven by showing A or B. So I need you to fit your case under A or B.
So we have the Heiser case and the Plot case and the Markowitz case. All of those cases talk about constructive notice. And all those cases talk about constructive notice with respect to employees being in the vicinity of the area.
Counsel, didn't all those cases involve some sort of an opaque substance, not clear water, that your client, who's immediately above it, assuming it was there, says she couldn't see it? So how could a jury infer that someone sitting over here can see it if the person immediately who just slipped on it can't see it?
But then we're weighing the credibility of the testimony. We're weighing the evidence to figure out who could see what. And that's not the function of a summary judgment.
Counsel, in order for you to look at whether they'd seen it, don't you have to show that it was there? Like nothing in the testimony I see shows when this water occurred. We've got 70-some people walking through in the few minutes before she got there. We don't know when the water reached a level that somebody could slip on it. It could have been the person right before her 30 seconds earlier.
And again, the case law is very clear that how long the item was there when we're talking about constructive notice is not relevant. So if we
Well,
look,
hold on. I'm looking at 768-0755A. Constructive knowledge may be proven by circumstantial evidence showing that the dangerous condition existed for such a length of time that in the exercise of ordinary care, the business establishment should have known of the condition. Seems to me like the length of time is super relevant.
so if we look at the Bennett case, the Brooks case, the Kostopoulos case, and the De Leon case, they all talk about how the item got there and how long it was there is not necessarily relevant when we're talking about constructive notice. And so
Don't you argue in your brief that this transient substance was on the floor for a period of time and therefore the store was on constructive notice?
yes, we argued that the lack of inspection for 25 minutes when they knew that
How did they know?
when they knew that rainwater being trapped into the store, even on a normal rainy day, and Mr. Wampler said we have to mop a lot. Sometimes.
But how did they know in this instance that
Well,
there was transient substance in that spot?
That's actual knowledge, and that's not what we're going under. We're going under constructive knowledge, which allows us to look at the lack of inspection. It allows us to look at all the elements that we set forth in our initial brief.
Counsel, is your position that we can go outside the statute? Because I'm telling you, there's a statute with 2 prongs, and you're telling me look at things not in the statute.
I'm asking
look
the
at standards
case-
outside the statute. I'm not bound by other DCAs. I'm bound by statutes. I've got a statute here that says there are 2 ways you can show constructive knowledge. I'm not going to not comply with the statute. That's not a thing I'm going to do. So there's a statute. There's 2 prongs. I need you to tell me which one you fit under.
The cases that we've cited are all after the statute's issuance. They all deal with constructive notice. There's
What's your best case?
I would say probably the cases that are, hang on just one second.
That post dates the enactment of the statute.
The McCarthy case, the De Leon case, and the Heiser, which is the district court case, and the plot case,
All right.
and the Radke case.
You are into your rebuttal.
Thank you.
May I please the court, Ashley Leisure on behalf of Applee Westgate. Appellant is effectively asking this court to hold Westgate strictly liable for injuries from a slip but not a fall on a small amount of water that occurred during Hurricane Irma's landfall. This would be in contravention of section 768.6.
Counsel, can you just go through the cases he mentioned and tell me whether we need a certified conflict with any of them?
Sure. All of the cases that he cites in the reply brief with respect to proximity, that includes Plott and Heiser, which he just mentioned, are distinguishable. Those cases were decided under maritime law and not Florida law, and they all have additional facts in addition to the proximity issue.
Sorry, counsel, did you say all 4 cases are under
No,
maritime law?
No, Plott and Heiser are under the
Plott and
maritime
Heiser.
law. The other cases, De Leon, Bennett, Brooks, De Leon involved shopping baskets, and there was evidence of a recurring problem with those shopping
So you're
baskets.
saying it wasn't a transitory foreign substance?
Exactly, Your Honor. In Bennett, there had been evidence of repeated warnings about the slipperiness. So that would put it into the category of regularity of the condition. And in this case, there is no evidence. I think one of the points that I wanted to touch on
Can you
was,
address McCarthy?
oh, sure. I'm unfamiliar with the McCarthy case, Your Honor. I don't know what the full citation is, but that's not one of the ones that I briefed. I'm going to be happy to supply information about the case afterwards. I don't know if the full citation, I'm referring to it by another name. The Brooks case, I think, was one that he also mentioned. That involved rain frequently seeping in under the door, and there was a lack of warning cones in that case as well. So that also makes it distinguishable. I think one of the important points that I wanted to raise is it goes to your point, Judge Mize, about the recurring issue. I think essentially what appellant is attempting to do is to draw an inference generally about existence of water in other locations and try to apply it to the specific location where Ms. Walton slipped but didn't fall. But I think that there is specific testimony to the contrary. And Mr. Wampler testified that water did not frequently cool in that area.
I was gonna ask you, if you say this was like in an aisle of a store.
Right.
And the substance, water, whatever it is on one side of the aisle
Correct.
regularly. And everybody says, yeah, there's, for some reason, there's a leak, it always gets there.
Right.
And for whatever reason, you know, the leak spreads in the ceiling, whatever. One day there's some water, say 2 feet the other direction. And it's undisputed. Everybody said, yeah, there was water on the right side of that aisle every single day. Everybody, all the time. Well, yeah, it was just there all the time. Everybody knew about it, right? And now there's water 2 feet to the left on the left side of the aisle. Would we say that that's a different area so that the regularity wasn't established, even though that everyone said there was water 2 feet to the side regularly?
I see your point, Your Honor. I think you're suggesting that there's a limit to the specific area that we need to be talking
Yeah,
about.
how specific do you need to be? Like how do you define the area?
Well, I think under these facts, it's very clear that the area was separated by a set of doors and it had mat in front of it. That's not the same area as the aisle that's 2 feet away. I think logically or foreseeably, on an aisle with no obstructions, water could move easily from one place to the other, as opposed to here, water inside a glass enclosure with double doors is not foreseeable to easily move outside of that. I think that's a separate area, and there needed to be specific proof that water was a recurring issue in that foyer. And in fact, Mr. Wampler said there was not. Ms. Harris said in the 12 years that she worked for the store that nobody had slipped there. So I think there's direct evidence contrary to the inferences that appellant is asking the court to draw, and I don't think that's permissible under Whitlow, Kemp, and Leftwich. I think also the testimony about the massive puddle of water, the court does not need to accept that. It's blatantly contradicted by the CCTV footage. You can clearly see that there's no water there until she comes back several minutes after her slip and shakes her umbrella and deposits water into that area. Again, I wanted to address the argument that the water is not visible, or the visibility to nearby employees. I think the case law is clear, and Your Honor is clear that that's no longer a factor that the court should be considering. Constructive notice can be proven exclusively 2 ways. One, that the condition existed long enough such that the business should have known about it, or it existed with regularity. Just being able to see the area.
What if it was on the border between the foyer and the inside?
I think that would be, a closer case, Your Honor, but I think here it's almost like there's a separate room, and it's hard to say, like, if there was a leaking air conditioner leaking in one room, would you expect that leak be transmitted to the next room over? I don't know that that's foreseeable. I think it needs to be the specific location or room in this instance, or aisle in your example.
Could you define the area as the place where people shake off umbrellas when they come in?
I don't think people are shaking off umbrellas in that.
Are people on the video, they're shaking off their umbrellas on the inside?
And it was also during Hurricane Irma, so people just sort of wet up,
So the inside is where people didn't stop in the foyer, shake, and nobody walked. Some people walked in a little bit through the foyer before they shake off their umbrella, right?
Of course, but I don't think there's evidence to support that was a regularly occurring incident that they were shaking off.
Well, it depends on how you define the area. If you define the area as the place where people might reasonably shake off umbrellas, and that's all one area, then it did happen regularly in that area, right?
Well, I mean, I think reasonably you would shake off your umbrella when you're coming from the outside and your umbrella is wet and you're coming into the foyer.
But people shook off their umbrellas inside. We saw that.
It's true, they did, yeah. But I still think that the area that is at issue, where the recurring problem was inside, where the mat was, where the cone was. If there was testimony that people were shaking things off outside of that, obviously then
Well, there's video.
But there's not testimony to support that that was a regularly occurring issue. And that's required under the statute. I wanted to briefly
Do
touch.
any of your cases deal with this issue of how we should define the area?
No, Your Honor, I didn't cite any cases specifically addressing the scope of the area at issue. Obviously, the legislature enacted the statute in 2010, so case law is still.
Yeah, you agree that's something we gotta do, right? When we look at the regularity of the condition occurred with regularity, we gotta define what is the condition, and therefore we gotta think about what is the area to
Right.
which the condition applies.
Of course, and I think here, if there weren't evidence directly to the contrary that it was not a regular recurring issue in that specific area, then appellant might have a better case for his position. However, there is evidence directly to the contrary. Wampler said, even on rainy days, water was not regularly accumulating there, and Ms. Harris also testified over 12 years, no one had slipped in that location. So the evidence is actually contrary to the inference that appellant is asking the court to draw. I wanted to briefly touch on the Markowitz case, since that was highlighted in the reply brief. As Judge Mize recognized, that's no longer the law in the foreign transient substance cases. Obviously, the legislature has superseded the duty with the statute. The duty is now limited to constructive notice or actual notice as delineated in the statute. There's not a duty to minimize or prevent or any sort of negligent mode of operation, cause of action recognized anymore in transient foreign substances cases. I also wanted to briefly touch on the duty to warn. I think part of the issue or the problem with appellant's argument is that at the center of the duty to warn is the necessity for there being a known dangerous condition. I think this goes back to what we were discussing. There was no known dangerous condition at this location. And then there's the specific employee testimony that's clear on that to the contrary. I think the Scott, Dideau, and Brooks cases, which are also mentioned in the reply brief, are distinguishable. They all had evidence of testimony of recurring slipping or water accumulation at the exact location where the fall occurred. I think that the Adams case, which was decided under maritime law, not Florida law, is instructive to the panel. It does talk about the scope of the area at issue. It's probably closest to our facts here. There, the 11th affirmed summary judgment for the cruise ship. There was an anonymous internet posting that was complaining about a leaking shower in one of the cabins. However, there were no guest complaints about the specific cabin where plaintiff fell. And because of that, the 11th said that there was no genuine issue concerning the constructive notice.
Counsel, if we could just skip to a separate issue.
Sure.
Westgate raises that at summary judgment, you didn't ask, or your client didn't ask, as to the duty to maintain the premises reasonably safe. Can you speak to that a little bit?
Sure. I think that it's clear from the case law. I think Owens, I block quoted it in the answer brief, specifically addressed it. That was the duty. However, with the legislature enacting 768.0755, it has eliminated that or superseded that duty. So there was no separate need to discuss the duty of reasonable care because it's been subsumed into the discussion of 768.0755. Adopting appellant's theory would be the equivalent of strict liability for transient foreign substances, and the legislature has explicitly rejected this. Businesses would have to patrol constantly for any liquid, regardless of the time that's on the floor, and that's not what the legislature intended with its enactment of the statute. The burden was on the appellant to show that there was a material, genuine dispute with evidence about constructive notice, and she failed to do that. If the panel doesn't have any more questions, I would ask the court to affirm.
Thank you. In conclusion, Judge, I would ask that you consider the inference that water was tracked into the store. Everyone knows it's conceded that rainwater is tracked into the store. The closed circuit television surveillance footage shows.
I don't think anyone disputes there was water in the store. The question is whether they had constructive notice on it. I don't think it's even disputed that water was in this place and she slipped. The question is whether they had constructive notice of the water in the store.
And I think if we consider the fact that 70 people walked through that area, clearly in the footage, all the water is not being deposited onto a mat that's drying it in.
No, I know. The question would be, at what point did this condition exist such that she could slip, right? And we don't know how much water was coming off each person, and you know, you've got a burden to show that this condition existed, either existed with regularity, right? Or it existed for such a length of time. There's got to be some evidence by which a jury could say that's a sufficient length of time for regularity.
I just think we get into a real danger when we start trying to define things within feet, especially when we're talking about people clearly traversing an area where there's clearly and indisputably water, and 70 people in 20 minutes shaking off.
But Counselor, you say 70 people. I watched the video. So you have, from the video's perspective, you're looking toward you.
Right.
Farthest away are the doors from the outside into the foyer. Next are the doors from the foyer into the store. You're with me?
Yes.
When your client slips, video shows her basically in front of the door that is to the viewer's left.
Yes.
With me? Many of those people that you're talking about traversing this area come into the store or go out of the store through that right door. Correct?
Yes.
So are you saying that the jury could draw an inference that water, assuming that it was on any of those people, dropped from there and then went over to the area several feet away?
I don't think it's several feet. I think it's a matter of inches. And so
Do we have to see the water, or the jury? Does the jury have to be able to see water falling off of these people?
I mean, we're talking about, when they zoom in, we're talking about grainy CCTV footage. We're not talking about, it's rain. Like we live in Florida. We know what rain does. And when my kids come in the house and they take off their jackets, or when my wife closes her umbrella.
We get it. This is an area where there could possibly be rain. Okay, I've got language of the statute. You've got 30 seconds left. What is the piece of evidence by which the jury could derive the length that there was enough water, length of time there was enough water there for her to slip?
You look at the cases that talk about the lack of inspection, the cases that talk about employees being in the vicinity, and the inference that water was tracked from the foyer to the opening where Miss Walton slipped.
Thank you.
We would ask the court to reverse. Thank you.
Thank you. Thank you to both counsel for your arguments.